Good morning to all of you. I suppose it's still morning in your part of the world. My name is Jan Wouters, and I have the honor and privilege of chairing and moderating this informal panel discussion on the diplomatic spat between the EU and the United Kingdom regarding the Union delegation in London. Maybe just a few words first about the context in which we are organizing this event. We do this in the context of the EU Diplo project. It's a Jean Monnet network between the universities of Geneva, Groningen, Pisa, and Leuven. And the network, which has kicked off in the autumn of last year, focuses on one big central question, and that is, what are the internal and external constraints, but also what are the aspirations and possibilities for the European Union as an international diplomatic actor? We did a nice kickoff conference in November last year, and this is one of our, say, ad hoc events, and we hope you will enjoy it, because indeed, we were really thinking that this diplomatic row that has broken out between the United Kingdom and the European Union over the status of the EU delegation and its ambassador in London is something really that touches upon some of the core issues that the EU Diplo network is studying. Well, let me just phrase very quickly the problematique. While European Union delegations and EU ambassadors in the world are given ever more state-like treatment, the UK Foreign Office insists nowadays that they should be seen as representing an international organization and should therefore not have afforded the privileges and immunities under the 1961 Vienna on diplomatic relations. This has created some tensions between the two partners. The new UK ambassador in Brussels has been refused meetings with the Office of the President of the European Council, and we can take it that for both sides there are important issues of principles at stake. And in this informal panel, we bring together practitioners and academic experts who will discuss this problematic from a legal and policy point of view. Let me quickly present our very distinguished panelists. We first will have an introductory remarks by Ambassador David O'Sullivan, who is former ambassador of the European Union to the United States and nowadays senior counselor at Steptoe and Johnson. We have with us Professor Eileen Denza from University College London, and I should highlight that Professor Denza is not only a world authority on diplomatic law, but she has also worked for a very long time for the Foreign Office, so she also brings an incredible practical experience. We then have Dr. Sandrine Duquet. So Dr. Sandrine Duquet is currently working for the Office of the Belgian Secretary of State for Asylum and Migration. A few years ago, she defended very successfully a wonderful PhD thesis in Leuven about the European Union as a diplomatic actor, a book that is now coming forward very soon with a prominent international publisher. And then we have, last but not least, Dr. Mauro Gatti from the University of Bologna, who has established himself already through numerous writings with regard to the EU in international relations and the external relations law of the European Union. So we are really grateful that those four eminent experts are with us. And without any further ado, I'm going to give the floor right away to Ambassador David O'Sullivan. Mr. Ambassador.
Well, thank you very much, Professor. Good morning, everyone who's watching in, and thanks to my fellow panelists who are eminently well qualified to discuss this issue. We were chatting earlier before we went live, and I made a remark which I'm going to repeat now, which I will qualify in the light of what one of my fellow panelists said. You know, it is in some ways a shame that we're having to have this discussion at the time of a global pandemic, a massive economic turndown, all the difficulties associated with Brexit for everyone in the UK and elsewhere, the problem in Northern Ireland. you know, it does seem to me that the diplomatic status of the EU delegation in London should be pretty far down the list of things that we need to fight about. I once, when I started my life in the Irish diplomatic service, I had a very experienced diplomat who used to say to me about protocol matters, those who matter don't care, and those who care don't matter. Now, of course, he was talking about personal pride and amour propre of people caring which bit of the table they sat at or where they were in the protocol line. This is not in any way to diminish the importance of protocol rules. We need protocol rules. They are absolutely indispensable in diplomatic activity. They provide a common basis for the treatment of diplomats in their host countries. And you know, you see this in situations which can be very difficult, where there can be conflictual situations, where we've had embassies attacked, where we've had attempts to intimidate diplomats. So there are very good reasons why we have the Vienna Convention and why we have a common set of internationally accepted rules for the treatment of diplomats. It also ensures a degree of non-discrimination. I say a degree because it ensures a formal non-discrimination in terms of the legal status and so forth. Of course, the American ambassador, the Russian ambassador will have privileged access wherever they are compared to, say, someone coming from Ireland. But that's a different issue. They are not treated differently in legal and in protocol terms. And I think this is very important that these rules exist and are respected. Now, in terms of the history of the EU delegation, I mean, I think the United States was the first to give diplomatic recognition to the coal and steel community back in the 50s. And one of our first presidencies was opened, indeed, in Washington. Of course, these were usually offices representing the high authority in the coal and steel case or the Commission. I myself worked for 4 years in the Commission delegation in Tokyo. We had full diplomatic status. We were recognized at that time, as all Commission delegations were in third countries. But, you know, we were sometimes by our own member states, we were not taken seriously as diplomats, right? They kind of thought, well, they're representing the Commission because we still had the rotating presidency, which chaired the meetings of EU ambassadors and was responsible for the coordination. They actually made the démarches to the Japanese government if such was needed. The Commission, of course, was always there. We played a very important role, but you know, there was a degree of ambiguity about the status, because the European community, as we then were, was clearly not a state. I mean, I think we can all agree on that. The lawyers will talk in a moment, but it may have it has acquired the characteristics of something like a state. I mean, President Delors, I think, described the European project as an unidentified political object. And this is a little bit the dilemma. So I certainly don't deny that, you know, you can make a case that the EU is not a state, it's not a country. Of course it's not. On the other hand, I think you can show the evolution through time of the recognition and status of EU delegations. And this certainly changed very dramatically after the Lisbon Treaty, where clearly overnight the Commission delegations were transformed into EU delegations. The Commission ambassadors became EU ambassadors, took on the role of the rotating presidency in the third country. So they chair the meetings of the member states, they make the démarches. This has been, you know, very much accepted by the member states and indeed by host countries. It rarely required a change of status in the mission, in the delegation itself, because they were all given full protocol status under the Vienna Convention, all the privileges that go with that. You know, I had a spat with the Trump administration, but it was not about the diplomatic status of the delegation. This was never questioned. I presented my credentials, as had all my predecessors, to the president. We had full, we were given the full credit of the diplomatic recognition of the Vienna Convention. The issue which was at stake in my case, I only mention it because people say it's similar. Well, it's not. The issue in my case was literally where you sat in the, or where you stood in the diplomatic precedence. The EU delegation was always at the end, after the member states, before other international bodies, and you didn't move up it with seniority in the way that an ambassador normally does. This was a mixed practice when I took over in the EAS. When we were setting up the EAS, we looked across countries. it was about 50%. We were recognized as the same as a member state with the precedents. In about 50% we were not. As it happened in Washington, we were not. I was asked 2 years into my time there, we got an instruction from headquarters to make démarches in all countries which had not yet done this. To be very frank, going back to my point about not being unduly upset about protocol, I didn't actually make the démarche myself because I felt it was a bit embarrassing because it was about me. I mean, it was about the ambassador. It was not about the mission. My deputy, Caroline Vicini, was a very experienced Swedish diplomat, former head of protocol. She made the approach to the Obama people. There was about 6 months of discussion, and one day she came in and said to me, hey, they've changed our position, and now you will move up the diplomatic list with seniority. I mean, didn't dramatically change my life, to be very frank, but I was pleased for the institution that we had achieved this full recognition. The rest is history. When the Trump people came in, a new head of protocol, and one day I turned up, as it happened at the state funeral of George H. Bush, to be told that my status had been reverted to the previous status, that I would get on the bus not as number 50, but as number 179. Okay, fine. In the end, this was reversed, and now the EU delegation in Washington and the ambassador have full diplomatic status and full equivalence with national ambassadors. Now, the point I want to make, and then I will conclude, is what saddens me is that the UK government has felt the need to make an issue of this. In the normal course of events, the UK has left the EU. They are now a third country, a sovereign third country, as they like to tell us. All they had to do was treat the EU delegation and our ambassador, João Vale de Almeida, in the way that every other country treats it. They have chosen to say, no, we need to take a second look at this. And I really cannot understand why, because when they were a member of the European Union, they were very supportive of the fact that EU delegations, of course, should be granted full recognition, and EU ambassadors should be treated the same as national diplomats. So it is indicative, I fear, of a more general problem that we have in post-Brexit relations between the EU and the British government, that this has now become an issue. And of course, I'm not saying that you can't make a legal case, for treating the EU somewhat differently if you want to. The question is, why would you want to get involved in this argument when there are so many other important issues and economically significant issues that need to be resolved between the EU and the UK post-Brexit? I find it very sad that we're having this discussion. I think it's a mistake on the part of the British government, because they are certainly not making any friends by doing this. And I also think they're wrong, because objectively you can see that everywhere around the world the EU has this status, and why would the UK want to be the greatest exception? So those are my thoughts, Professor, as an introductory remark. I mean, I think this is, unfortunately, once you make it an issue, it becomes an important issue. I don't think it should have become an important issue. I know talks are ongoing. I'm not at all privy to what's happening. Maybe some kind of compromise can be crafted that enables both sides to sort of feel that they have protected their interests. But as I say, I just think it's extremely regrettable that we are having this discussion, which really, based on all the evidence around us, there was no need to raise as an issue. Thank you.
Thank you very much, Mr. Ambassador, for these interesting remarks, and especially for sharing your experience as ambassador in Washington, D.C. Let's turn immediately to Professor Elaine Denza for her view on this particular issue. Professor Denza.
Thank you. I don't believe that the UK has suddenly thought of this as an issue, or indeed that it results from its antagonism to the European Union. I would like to start by giving how the UK see the European Union, and from that I'm going to quote from Satter's Diplomatic Practice, in a chapter which was written by a serving UK diplomat. And what it says is, what is clear is that the European Union and its predecessor, the European Community, have acquired wider powers to conduct international relations than any other international organization. However, this goes on within the limits. International organizations can carry out many of the functions exercised by states, including international agreements, participating in other international organizations, making formal statements and representations, and undertaking actions. But turning to a slightly later paragraph in the same book, Satter's Diplomatic Practice, is the quote, while the heads of EU delegations are accorded the courtesy title of ambassadors and their delegations referred to as diplomatic missions, they do not exercise the full functions of the diplomatic mission of a state. They can only act within the limits of the powers conferred on the Union. And then it goes on to explain that their status is in the matters of privileges and immunities are governed by special agreements in each case, and not by the Vienna Convention. Going back to the functions and why, even though the European Union has got extraordinary powers, it hasn't got the full range of the diplomatic functions. They do not negotiate across the full range of possible subjects, but only where the Union has competence. And of course, that competence is increasing, has increased over the years enormously, and it continues to increase. They do not, in the full sense of the Vienna Convention, protect European Union citizens. That's a very complex issue. They have some powers of protection, but not the full range of diplomatic protection. Another important difference in the context of immunities is that there is no reciprocity. And reciprocity is the cornerstone of the very wide observance of the Vienna Convention rules among states. You give immunity to people that you don't like and would prefer not to give immunity because it protects your ambassadors in their state. Now, the European Union does not directly do this. It has to ask Belgium to provide the reciprocal degree of immunity, which of course it does very successfully. Now, because of that, there's always, from the outset, there's always been a lack of reciprocity in the treatment. From the outset, states sent ambassadors and diplomatic missions which could perform the full range of function to Brussels and to the European institutions. And strictly speaking, what were originally the Commission delegations and then became the Union delegations were given the courtesy title of ambassador and diplomatic missions. In many contexts, they were treated the same, but essentially they were a little bit different. Now, the UK hasn't thought up its approach to be difficult with the European Union, quite the reverse. The starting point in the UK is that immunity are a derogation from the rule of law, legal rules which are binding on diplomatic missions and on diplomats in their official acts and in their personal capacities cannot be enforced. And essentially, the present dispute goes to the full range of personal immunity. Inviolability means that even if there is machine gun shooting coming out of a mission, as happened in London when I was still there, or someone goes into a mission protected by inviolability and is cut into pieces, as you all know happened again much more recently. The police cannot go in and investigate. They are precluded. They have to stand outside and negotiate with the inviolable people. So inviolability is not just a matter of prestige, it's a matter of giving not an exemption from the law, but a situation where the law cannot be enforced. There's no dispute about giving the European Union functional inviolability immunities for all its staff and inviolability for its premises. That's not an issue. The issue goes to the full Vienna Convention. And this just illustrates that this is not a trivial matter. I'll just take two cases that I've been personally involved in that have been in the news in the last week. One of them was the Saudi case, where an Iranian diplomat has been found guilty in Antwerp. And there is an issue about whether he was correctly treated as not having immunity, but he was denied immunity and convicted of an attempted bomb attack on a very large rally to take place in Paris, which would have killed a very large number of people. And on a much more minor level, one in the UK involved the wife of a diplomat. The diplomat was 100 miles stationed out of London. There was a complex arrangement, and under that arrangement, probably as a matter of oversight, his wife was immune, and she drove out of the premises and on the wrong side of the road. She'd only been a few days in the country. It happens to a lot of people accidentally, but in this case, she was terribly unlucky. She hit a 19-year-old motorcyclist and she killed him. She was withdrawn, and the UK government has been under a good deal of criticism over the fact that she was immune and that she was withdrawn. So I simply cite these cases to show that the matter is not just an issue of protocol where the UK can pick and choose what it does. It is essentially the issues under dispute go to a matter of law. The protocol thing could be dealt with possibly by executive. The immunity for personal acts, which I think is the main issue in the case, I think we need primary legislation in the UK. Going back to 1950, when the UK decided it couldn't be having an act of parliament for every single international organization, because it's a member of somewhere between 130 and 150 international organizations, introduced a procedure whereby international organizations were given immunity by order in council. I spent a lot of my very young days as a diplomat defending these orders very late at night in the House of Commons, where they were bitterly attacked. So the tradition in the UK is to say, why do you need this full range of immunities? The work you're doing is not controversial in the way that a diplomatic work may often be. They're not operating in a hostile environment, and there is no question of reciprocity. So the UK has always been an outlier in the matter of continuing to say that immunity should be justified on the basis of functional need. And again, going back to when I was in the office, we found that international organizations in London were taking the view, other countries are much more relaxed. Why don't you just go along with the general run. And we, under the auspices of the Council of Europe, convened a working party that went on for several years, in which we tried to persuade and succeeded in persuading the other members of the Council of Europe that international organizations were not the same. The UN could functionally justify a very high degree because it operated missions in very sensitive and difficult conditions. But the ones that were causing us problems in London, for example, the commodity organizations dealing with international sugar, were not going to have rioters stoning their windows. And there were a large number of commodity organizations threatening to up sticks and out of London. And we dug in the UK dug in our heels, and we did get this survey published. And for a long time, it was quite successful. Then, as things happen, it got rather forgotten. So we do come up against, well, everybody else is doing it. They don't care. Why should you make it an issue? Well, we didn't make it an issue. We simply stuck to what the position, stuck to a position we'd had since, well, before 1950. So it is the European Union who are asking for more, and they've been hugely successful. And what the UK have been saying is, we don't accept all of this. There is, I think, just going back to the practicalities, I haven't totally researched the powers under the new legislation, but I think it would be likely to require primary legislation. And I think that taking this at present through the House of Commons would be extremely difficult. So I stress no problem about functional immunity, no problem about inviolability. I believe the protocol issue could be dealt with, because that's not a matter of law, but of practice. So essentially, I'm trying to explain that we didn't invent this as a way of being nasty to the European Union, where we, the UK, are trying not to do that. I'm not saying we've always succeeded. So I think that's the essence of trying to justify the European, the United Kingdom sticking to its guns, which are guns that go back many decades. Right. Thank you.
Thank you very much, Professor Densa, because I think for many of us this is a really very welcome and important clarification of the UK position, and in a way contextualizing that position in a very long, historical tradition. So that's very, I think, informative. May I now call upon the young generation of panelists, if I may call them that way. In the first place, Dr. Sandrine Duquet, to share her insights with us. Sandrine.
Thank you, Chair. I also wish to thank the previous speakers for their intervention, and I'll try to supplement their presentations by giving a somewhat more historical perspective or an overview of the topic at hand. During the course of my PhD research on EU diplomacy and diplomatic law, questions of the sustainability of the EU's practice of contracting in the 1961 Vienna Convention on Diplomatic Relations through bilateral arrangements has been one of the more interesting questions, and it was actually a very central question. It's been something I've been thinking about quite a lot in the past, and I remember even arguing, well, maybe not the most elegant way to legally solve something, but at least, hey, it works, and all these, you see all this practice of all these countries and third states accepting it. So perhaps we shouldn't really bother with the questions of legal basis and so on. Well, of course, the UK's perspective changes this completely. And I believe it is of use to take a step back and see how the EU constructs its diplomatic actorness and convinced over time the third states to accept this, including the application of the international rules on the diplomacy. Of course, as many of you know, the sending and receiving of diplomatic missions is a very old phenomenon. Since the 12th century, you have permanent missions, and ad hoc diplomacy is even older. But it's only with the birth of the modern nation state, so in the mid-17th century, that sovereignty and therefore also diplomacy became attached to states. So perhaps before that, it wasn't really too hard to negotiate a deal with the third states, to have another actor than a state recognized to receive privilege and immunities. So the protection of diplomats in foreign states' territories has always been guaranteed by customary law. And from a very early point onwards, it was clear that ambassadors had to be treated according to certain formal and ceremonial standards, and that they enjoyed certain privileges together with their mission and the staff. And it's only actually in 1961 that these customs were codified in the Vienna Convention. I think it's important to keep this historical perspective in mind, because it's only then that the convention really clearly spelled out that the rules that it created were applicable to states and states only, because only states could sign the convention, although the practice was dating back even centuries before that point. And this is where it gets problematic, because at that point the European Union had already started to engage in diplomatic relations. Of course, as an international organization, it's not the sovereign states, and then suddenly you have this big convention that codifies the rules that had been customary law before, and continue to live on as customary rules, of course. But the EU has always acted in a diplomatic way, even before the Vienna Convention was signed and the Union was still the European Coal and Steel Community. There were external and diplomatic relations, and in a way that the European practice just predates the codification of the rules. So it's not that weird from a historical perspective either for the EU to demand customary rules that customary rules are applied to it. And I believe the best proof is the fact that already in 1956, the High Authority, so the predecessor of the European Commission, decided to establish a permanent mission with diplomatic tasks in the United Kingdom, which back in those days, of course, was not a member of the organization. And the London delegation was, in fact, one of the first missions of the European Coal and Steel Community in a third state, as was mentioned by Ambassador O'Sullivan, together with the US mission. So there was some practice here. And then from the very start, the mission considered it within its remit to diplomatically represent the coal and steel community, and soon thereafter also the other communities. And the UK accorded the mission certain privileges, including CD license plate, immunities, and the head of mission even had sort of an ambassadorial status in the 50s. But there were some difference with other bilateral missions even back then. So I think that this relates to what Professor Denza was saying. So in contrast to the EU head of delegation or the coal and steel community's head of delegation, the staff enjoyed only limited diplomatic privileges and immunities, and there were some inequalities. The European representative was accredited to the UK government and not, as was common, I understand, for foreign ambassadors to the Court of St. James. This meant, for instance, that the head of mission was not allowed to participate in meetings of the diplomatic corps per se. But in the meantime, the High Authority had already signed an agreement with the United States to open a mission in Washington, D.C. But for the first couple of decades, the mission in the US was officially operated as an information center. So the practice in the UK went way beyond that. So the US mission was firstly not really seen as a diplomatic mission. During the 1970s, you see that the commission representations were then more or less randomly established with a preference for strategic partners, US, UK, of course, but also Japan and others. And then on the other side, you had the practice in development cooperation countries. The US formally accorded the commission delegation full diplomatic status in 1972. And then you saw that there was a real preference to open in the 1960s and 1970s delegations in Africa, reflecting preferences of individual member states. Post-colonial interests played a role, and also common focus on implementing a development policy common to the EU countries. I think the real game changers was 1974, when the European Commission concluded its first establishment agreement with the Empire of Japan in order to establish a commission delegation in the country. Although other delegations had been opened, as I explained, this was the first one where it was agreed that a formal agreement would be used to define the legal framework. And that agreement still functions as the model agreement for all the other EU delegations. So whenever there's a new delegation opened, that model from 1974, with some slight changes over time, is used to ask the third country to grant Vienna Convention treatment to the EU delegation. So the Vienna Convention remains the starting point for the immunities and the privileges of the EU delegation. Through a special clause in the establishment agreement, the EU can apply the rules contained in that convention. So there's, in legal speak, it's more of a referral in the establishment agreements, which are very, very short agreements. Actually, there's a big reference to the Vienna Convention and a couple more clauses, but it's not a really big treaty in itself. And this practice only got a legal basis as something interesting as well in the 2010 EAS Council decision, not even in primary law. So it's since the 2010 that the High Representative is tasked to enter in such establishment agreements with third countries. So the approach of signing establishment agreements in the mid-70s did not immediately result in the abandonment of the former technique of just requesting third states to adapt their domestic laws on immunities. And still this day, not all third countries have signed an establishment agreement with the EU. There are a number of countries, the US, Canada, Venezuela, Thailand, Australia, Switzerland, that have unilaterally granted the EU delegations Vienna Convention treatment, but through an adaptation of their national law. So they have a national law in place that says that the EU is granted such immunities. But overall, the last time I counted, there are 132 establishment agreements in force, and then a couple of those unilateral agreements, national laws that count. And then, but all of them, you see a clear pattern, and then if you take them together, all of them do the same thing. They grant or they recognize the EU as a diplomatic actor, which should be granted the full diplomatic status. So this resulted in a web of agreements which nevertheless works or worked in practice. Even to such an extent that when I defended my PhD, the question really popped up whether customary international law was created. Because if all the countries started acting in a very similar way without any discussion, this was a question that popped up and was at that time and still is actually a very good one. On the other hand, it is also unclear whether these unilateral concessions can be revoked or the contracts that the third states have signed on to with the EU can be terminated by just one party. It's also not excluded. And perhaps some final remarks. I think it is quite remarkable that it was the UK that in the late 1980s was quite insistent on extending the establishment agreement technique to third countries. It was one of the member states who was more vocal about this and really wanted, especially with countries in Africa, to have this formal legal arrangement concluded. And after the wall fell in the 1990s, the same story goes for the former Soviet Union countries. And it's quite clear that the UK policy then was to demand third countries to accept this EU approach on dealing with the issue. So not accepting the EU status in 2021 feels somewhat hypocritical in that sense. And although I understand from Professor Denza's explanation that there are certain legal hurdles to it, it's still a bit of a change from well, how countries react as a member state and how they react as being a third state. Now, obviously, one major concern on the EU side is how this will reflect on the system as a whole. And as explained, it was maybe not the most legally solid from the beginning. But to put it more concretely, how will other countries react? Will this change the precedence? Will this have a precedence value? If the UK's decision is not revoked, will it inspire other countries to rethink their relationship with the EU and with the EU delegation? So this is very problematic, not on a geopolitical level. We have seen just the example of how relations with Russia are not always that smooth or as smooth as the EAS would want them to be. But there are also serious questions about the safety of EU officials, and I think this will be one of the concerns for the EAS as well, to just protect their staff abroad. And of course, if you have full Vienna Convention treatment, it's slightly easier than if there are all kinds of ad hoc arrangements that would be in place in third states. So would be interesting to see if the UK continues its approach to this question, and then whether other countries will follow suit. So I think it's a serious issue, and I hope a solution can still be found, of course, to avoid this scenario. But for now, I'll limit myself to these introductory remarks. Thank you for the attention.
Thank you very much, Sandra, and I hope I'm not, say, telling a secret that I guess you are one of the sole persons in this world who has basically collected all of the existing establishment agreements of the European Union and has really made the kind of personal repository of them. So, I mean, if there is anybody who can really talk about that practice, it is actually, it is you. So let's now turn to Dr. Mauro Gatti. Mauro, a lot has already been said, but I'm sure you will definitely be able to add your own perspectives to this. May I already mention that you have written already a very decent contribution about this diplomatic spat in Italian, but also a version in English. So I'm not sure if you are prepared to share that with the rest of the participants, but first please intervene, and after your intervention we're going to open up a little bit. Thank you, Mauro.
Thank you very much, and thanks also for the invitation to this wonderful event. The contribution you mentioned will be published soon in the blog of the European Journal of International Law, so tomorrow or Monday at the latest. Anyway, I would like to, well, follow your suggestion, the suggestion you gave to disagree with the panelists, if you don't mind. And I will start with partially disagreeing with Dr. Duque on the existence of an international custom, in the sense that, if I understand correctly, you neither affirm that a custom relating to the diplomatic privileges and immunities of the EU exists, so you didn't say whether it exists or not. In this sense, I will partially disagree with you by saying that, in my understanding, such custom does not exist yet. It might be in the process of being created, but it seems to me that it does not exist for two reasons. First, because there are still a few countries that do not recognize diplomatic privileges and immunities of EU delegations, and that's also obviously the UK, but also Canada, if I'm not mistaken. If I understand correctly, Canadian law only recognizes functional privileges and immunities of the EU delegation, at least formally speaking. I don't know about the practice. Probably you know that better than me. And the second reason why I would doubt about the existence of such a custom is that the EU itself did not claim that the UK is violating international law. So if the Union does not argue that such custom exists, well, I doubt whether the custom might even be supposed to exist in the first place at present. Although it is clear that maybe the custom might come into being in the near future. So in light of this partial disagreement with Dr. Duque, I would agree with Professor Denza about the fact that the UK is well within its rights not to grant the EU delegation in London diplomatic privileges and immunities under international law, of course. But I would very respectfully disagree with Professor Denza regarding the fact that let's say whether there is a need for diplomatic privileges and immunities. As Professor Denza correctly mentioned, the rationale for diplomatic privileges and immunities is functional, in the sense that they are necessary for the performance of diplomatic functions in practice. And as a matter of fact, in my understanding, and as Ambassador O'Sullivan mentioned, EU delegations are to a very large extent similar to national embassies, and paradoxically, perhaps, the most similar one is the one in the UK. The main difference between EU delegations and national embassies is that EU delegations are not able to protect EU citizens, at least not generally. They can coordinate protection in case of crisis, but it's relatively rare. But that's different for the EU delegation in London, because the EU delegation in London is responsible for overseeing the application of the withdrawal agreement of the UK. And this agreement confers rights on EU citizens. And these rights must be protected by the European Union, and only the European Union, not the member states, because the withdrawal agreement was concluded by the European Union as an EU-only agreement. Therefore, the potential violation of the agreement, the potential violation of EU citizens' rights can only be invoked by the European Union, which means that only the EU delegation in London, not the Embassy of Italy, not the Embassy of the Netherlands, only the EU delegation can actually make representations to the UK government, exercise consular protection in favor of EU citizens with respect to the violation of their rights as guaranteed in the withdrawal agreement. And I would like to stress that this is a rather exceptional situation. The UK is the only country where this actually happens, or should happen in principle. So in a way, I think that the EU delegation in London is actually the delegation that is most similar to the embassies of sovereign states. Having said that, it is kind of self-evident in my understanding that all the other diplomatic functions are also performed by delegations in general, and the delegation in London in particular. Negotiation, representation, information, promotion of friendly relations. I think that there is not much about that. And I think that after the Treaty of Lisbon, it is also quite clear, at least in my understanding, that EU delegations operate really across the board, working not only on commercial issues, which was the case in the 60s or the 70s. Delegations today also deal with foreign policy issues, stricto sensu, the common foreign and security policy, briefly. So all in all, I think that it is difficult to argue that EU delegations, and specifically the EU delegation in London, are functionally different from the embassies of states. Actually, they are very similar. And in my understanding, this functional similarity should justify, should motivate the recognition of diplomatic privileges and immunities for EU delegations. All the more so because, and here I also respectfully disagree with Professor Denza, all the more so because there is reciprocity between third states and the European Union. Obviously, the European Union does not have a territory, does not have a police, therefore cannot protect and cannot grant privileges and immunities to directly to the missions of third states. It must rely on Belgium, as you correctly mentioned, Professor Denza. And it does so via Article 16 of Protocol 7 to EU treaties, which actually requires Belgium to protect the missions of third states accredited to the European Union. So there is a triangular diplomatic relations here. The existence of this triangular diplomatic relation, however, does not imply the absence of reciprocity, as European institutions have repeatedly stated over the years. And this for a simple reason, that if the European Union does not want to recognize privileges and immunities, does not want to accredit the mission of a third state, well, Belgium will not recognize privileges and immunities to that mission. So in my understanding, the European Union can easily today request Belgium to downgrade the UK mission to the EU. The same way the UK does not recognize the diplomatic privileges and immunities of the EU mission in London. And that's actually the solution I would suggest to European institutions if the UK government did not change its mind. Precisely because the European Union must protect this principle that EU delegations should be granted diplomatic privileges and immunities, the EU should react to the action of the British government in a reciprocal manner. And I believe that, of course, such an outcome will be probably not very efficient in the broader terms, considering that, as Ambassador O'Sullivan has said, we have more important things to deal with at present. But I think that this outcome is kind of inevitable unless the UK government somehow decides to modify its policy. And I think that it is, in a way, easier for the UK government to modify its policy than it is for the European Union. Because for the European Union, it's somehow an existential issue, not in the sense that the European Union would disappear if its missions did not have diplomatic privileges and immunities, but in the sense that being recognized as an international actor has always been an objective, the objective of the European Union in foreign policy. And receiving diplomatic privileges and immunities is part of this strategy, has always been. The European Union might not say it openly, but if you look at the internal documents of the European Commission, you can see it clearly throughout the history of European integration. Now, the fact that the United Kingdom, the closest ally in a way of the European Union, denies diplomatic privileges and immunities to the EU delegation in London is, I think, a contradiction of the EU's strategy, which is also a contradiction of its own self-perception and the way the European Union wants to be perceived by others. So in my understanding, the European Union simply cannot let this pass, and I think should not let this pass. Thank you.
Thank you very much, Mauro. Now, we have had 4 great introductory remarks, and we are now entering in the second half of our informal panel. We are entering the interactive, phase. I was wondering whether some of our participants may have questions that they can put in the chat box. I haven't received such questions apart from a comment that one of the participants likes my European tie. Which actually is not meant to be a declaration of solidarity with one or the other position in this particular debate, I should stress. But so before we receive questions from our over 120 participants, maybe I would kindly invite the panelists themselves to maybe interact a little bit with each other, because various positions have been expressed, and I could imagine that some of the arguments may require a further reply or deepening of the discussion. Could I start by, let's say, going back to the order of, interventions, and maybe first check if Ambassador O'Sullivan would like to intervene and say a couple of additional things? Ambassador?
Yeah, thank you. Well, I'd like to thank all my fellow panelists whose knowledge of this area is infinitely deeper than my own, I have to say. I had never quite realized how deeply you could delve into diplomatic law. I would like to thank Professor Denza for her very, very thoughtful and helpful, I think, explanation of how this is perceived in the UK. And I get the point, particularly if there was an issue of having to introduce legislation, because we all know the difficult issue in the UK Parliament of anything to do with the EU these days. Having said that, I just want to pick up on a couple of points, if I may, and my fellow panelists, Mauro and Sandrine, have made these points. I mean, particularly Mauro, I think, made the point I wanted to make about reciprocity, which I think is important, that the reciprocity is functionally delivered through the Belgian system. Thank you. We're very grateful to our host country, who looks after us in many ways, but it is functionally delivered through the Belgian system, but is in fact at the behest and at the explicit decision of the European institutions. So there is an element of reciprocity. Now, the 2 points I particularly wanted to pick up on, or 3 points, if I may. One is, the fact is the EU, it's an international organization, Jim, but not as we know it, right? It is sui generis, and this is why I think it has been recognized across the world as being different, and EU delegations and EU ambassadors are treated differently to other international organizations. And I think this reflects the fact that it has exclusive competence in many areas to conclude on behalf of member states, trade being an obvious one. But also, as Mauro said, in terms of the specific situation of the UK delegation of the European Union, it is the supervision of the withdrawal agreement and the GCA. And as we're already seeing, this is complex and does involve, as Mauro pointed out, EU citizens. And the other point, wanted to come back to was the issue of safety, because Professor Denza said this was one of the important reasons for immunity. And I wanted to pick up on what Sandrine said, that there are many EU delegations in situations of extreme danger and extreme risk. And one of the things when I was Chief Operating Officer of the EAS, one of the things I genuinely lost sleep about at night sometimes was the safety and security of our delegations in some very, very dangerous places, Afghanistan, Yemen, other places. So I think Sandrine's point that for the EU to give up the principle of immunity for its staff in the UK as a precedent for that then being used by more places where I agree the rule of law is distinctly less reliable than in the UK, I think this is a very big issue and one that the UK should have sympathy for. If I were being a little bit frivolous, Professor, sorry, when you said, well, you're operating in a hostile environment, I think the EU delegation in London probably is operating in what you could call at least a hostile environment in terms of media, but I agree, it's unlikely that their lives are threatened. The other point I just wanted to make, because I think it is very important, is the issue of immunity itself. I mean, what does it mean? How do you invoke it? I think one thing is very, very clear. The European Union has always taken a very restrictive view of immunity. I mean, I can tell you that all our delegations are under strict instructions that they may not use their immunity to not pay parking fines or all these kind of things which some other embassies play fast and loose with. And the lifting of immunity, of course, is something which can always be requested. I mean, the United States chose not to lift the immunity on the lady in question. Now, we're not going to go into that case. You probably know more far about than that. But I think if you look at the history of the European Union position, including our immunity in Belgium as officials, there has always been a relatively open position to lift any immunity on European officials where they're in situations which are clearly, to do with civil law and personal behavior and not an issue of behaving in their function. So I get that this may be slightly complicated in UK law, and I defer to your knowledge of the issue. But I think really I come back to my final point, and this is what I just want to say, Jan. This should all have been dealt with discreetly and quietly months ago. We should not be stumbling into this situation at the worst possible moment with arguments about the implementation of the Northern Ireland Protocol and shellfish exports and all of that. We're now mixing all this together. My deep regret is that it was not found possible. This was a problem you could have seen coming from the very beginning. In fact, I must say it crossed my mind when I heard someone talking about, who's going to be the EU ambassador in London. I even said to my wife, I said, watch out, I bet you they're going to create a problem about the status of the delegation. And that was a year ago, before I knew anything, by the way. I didn't even know who was likely to get the job. So this is what I regret more than anything. And I think this could all have been avoided with much earlier discussion if there are real issues, and I do not diminish the points made by Professor Denza from a UK perspective, but I think there are solutions to these problems which could have been found discreetly and quietly, and this should never have become the kind of public issue that it now is.
Thank you very much. We turn to Professor Denza, but Professor Denza, in the meantime, I'm receiving all kinds of questions from our participants, and there are already, some questions that I think would be usefully addressed by you. Can I just give you two of those questions from our participants as well, so that you can react to those questions and also to some of the points of view taken by the other panelists. I have one question that say you have been saying that the United Kingdom is not being nasty, but is basing its position on legal precedent. And the question is this more than a technical issue? And the person who asked the question wonders whether there isn't really a political element in the United Kingdom position. One of the other persons who asked the question, but I'll come back to that, is also wondering whether the strategy is not actually more or less analogous to what the Trump administration did with the EU delegation in Washington, D.C., to downgrade the EU under the motto divide et impera, divide and rule. And so that is say the question whether there is not something more political involved than just a question of president or technical issues. I also got another question from a colleague that with regard to the argument that the United Kingdom would like to avoid setting a precedent, for instance, being bound to grant full diplomatic status to other international organizations. And the question is this really a convincing argument? Because technically speaking, there is no obligation of non-discrimination among international organizations on the part of the host state. Well, subject of course to whether or not there is a most favored nation clause in the headquarters agreement. But so, I mean, these are two questions that go a bit in your direction based on the arguments that you used. Could you kindly take them into account? And please, the floor is yours.
Yes, perhaps I might, just before turning to the extra question, two things I would like to say. One is I think it's important for people to realize that there is no argument about functional immunity, because some of the points raised are about the possibility of the UK not being prepared to grant functional immunity for official acts or inviolability. As to the personal status of the ambassador, I don't, without seeing the detail, think that that would be a problem. The high officers of international organizations since 1968, and that did require primary legislation, which I was very much responsible for, do get the full diplomatic treatment. What is not given is all the way down to drivers who are only protected for hitting people officially in their careless driving or cipher clerks at a more junior capacity. So the argument is about must be kept to the full range of the personal immunity, and remember it's under the Vienna Convention treatment, and that's illustrated by the American case. It isn't just the officer that is given immunity, but members of the family forming part of the household. So that's the night clubbing 19-year-old or 17-year-old who goes out on the spree, and of officials under the Vienna Convention, they're entitled to personal immunity from criminal jurisdiction. And the other point I want to make, which really relates to what Dr. Gatti said, is that I no reason to suppose the UK would object to reciprocity in the matter of immunity. What I think is a pity is that and I don't believe this is the fault of the UK, of the EU saying, well, if you don't give us everything we want, we're not going to talk to you at senior level. Nothing I've seen implies that that's appropriate, or that the UK started this. As to whether there's a political element, I would. I'm not, as I say, I'm not party to what the thinking is of UK ministers or officials. I wouldn't have thought that when the difference began that there was a political element, but what I do believe is that if the UK found it had to introduce some form of legislation to grant the Vienna Convention Treaty in the House of Commons, there would be a political argument into the approach taken by a large members. So it's got the potential to be very political. A lot of people have said it's political. I can't speak for the UK government, but it would certainly become political if it went to the the House of Commons. As to non-discrimination, I don't agree with what I've seen the UK saying, is that it would open the floodgates. I don't, to the extent that argument's being used, I don't think it's correct. International organisations should be treated with regard to their functional need, and that's what the UK has tried to do consistently, fairly consistently. Going back to the host state agreement, I think that there may indeed be a case for full protection for staff by special agreements in very dangerous missions. And to some extent, this is a matter of common sense. I think the EU began getting a very high level of treatment in the countries where there probably was a justification for it. The other aspect, apart from physical danger and actual war zones, is when you're in the part of the reason for diplomatic full status, going beyond the functional, is the likelihood, and I've got a lot of experience of this in the Cold War, trumping up charges, deliberately engineering, let's take Moscow at the height of the Cold War, that it was possible to engineer a situation where a diplomat appeared to have been involved in a very nasty accident. And the immunity for personal acts, and that would include driving off duty, would protect him, and it was that kind of hostile environment. I agree that the EU is not going to find things necessarily friendly and welcoming from a lot of quarters in London. I sympathise with them over that. I don't think it's going to extend to the agents of the UK government covertly or otherwise engineering them into sting operations or compromising positions or traffic accidents simply to take advantage. That I don't think. I think the UK is. I may be too trusting, but I don't think that's going to happen in the UK. But I don't believe the UK is or should be averse to saying. I'm a Latinist, and I'm always a bit suspicious, in fact, because this sui generis was used a lot in the time of the Treaty of Maastricht, and on the basis that it put an end to the argument about whether the European Union was or was not an international organisation. So I've always, it's like the word sovereignty, it's many faceted, and it's probably better not to use it, but right, I think that I hope that argument answers the questions directly addressed to me.
Thank you very much. Now we turn to Sandrine and Mauro again. In the meantime, I've received 2 questions which actually are addressed to the 2 of you, so let me just give them already. First of all, one question is about yes, customary international law. And the question is, do we need 100% acceptance by all states of EU status before we can talk about customary international law? I mean, I guess this question you will definitely answer. And then I got another question. In fact, that other question, if I may identify the person who made the question, that's our friend and colleague, Professor Ramses Wessel, who is also the main coordinator of the EU Diplo Jean Monnet network, and his question is both also to Sandrine and Mauro, and the question is, to what extent does it matter in a legal sense whether the delegation is recognized as similar to a state embassy or as the permanent representation of an international organization in the UK, as long as privileges and immunities are recognized? Okay, there are some other questions popping up, but I would like you, if possible, in your interventions now, not just to respond to the other panel members, but also take those 2 questions into account. Sandrine.
Thank you, Chair. I was planning to focus a bit on the customary international law question. It's a question I don't really like to address because it's very difficult, and I think that there are different legal questions that deserve a different approach. I do think that the decision for the EU to establish an EU delegation is much closer to being accepted under customary international law than the actual rules that would apply to that delegation. I think it's fairly accepted that the EU can have offices abroad interstates, and there's no question about it. Whether when it comes to the actual treatment of the delegation, this is a much more difficult question. I think that we have to go back to the legal criteria for customary international law to solve such an issue. So we need practice first and opinio juris second. So the practice is there, overwhelmingly so. And answering the question from the audience, the practice does not have to be perfect to have a rule of customary international law. I think that's been said by ICJ cases on numerous occasions. The overwhelming practice that there is, diplomatic status accorded to the EU delegations, should suffice, in my opinion. But when it comes to the opinio juris, the fact that states also believe that the rule was created, this is of course the gist of the discussion, and I don't think that's the strongest argument. So I don't think states, when they concluded that their establishment agreements with the EU, really thought this through as that they felt obliged to enter in such rules. I think that they wanted to do so for all kinds of reasons, mostly political, probably, but whether they accept that they're bound by such a rule and that they had to enter in an establishment agreement, I guess that's a more difficult discussion. But in any event, I also do not think that the legal qualification, as there is a rule of customary international law here, would solve anything. This is a political discussion, obviously, and then I wouldn't recommend the EU or the EAS to use this argument because it won't solve anything. And I think when Ambassador O'Sullivan just said that the EU delegations are very strict on monitoring the behavior of diplomats, which is of course a part of good practice, and every country in the world should do that and then lecture their diplomats on how they should behave on foreign territory. But there's something more to that as well. The EU does lecture its diplomats just because they don't want, I guess, it's a personal feeling, they don't want cases to start leading their own lives, and they don't want one small case, one traffic accident, one smuggling incident to cause a big row and then start questioning the whole system. I think that's actually the reasoning behind it, and so that's why probably the EU also doesn't use the argument of the customary international law, because perhaps honestly they doubt themselves whether such rule exists. Rather, I think the political arguments are more important, and most of the third country states would look at the political consequences of not granting the EU the status that it wants to see granted. They would lose communications with the EU. For many countries, it's also a question of power. The EU is a major trading bloc, larger development cooperation actor in the world. And it's even so for the UK, where the EU is worth 55% of all the UK's trading, if I'm correctly. So the political aspects are probably more, and if I would have to advise the EAS, I would also use the political weight more than the strictly legal argument on the basis of the customary international law discussion. So, and then this relates back, of course, to the points made by Ambassador O'Sullivan about whether the EU should handle this more discreetly or seek this open confrontation, use the diplomatic instruments at hand to convince the UK to change its position. I personally tend towards the first, to keep looking for a discreet solution. It should have been dealt with months ago, that I do agree with Ambassador O'Sullivan, but there is still room in it, and this already has gotten too much attention, including by me. So it would be good if it can be, this thing can also go away in a more smooth way than then and now. For Professor Wessel's question, of course, yeah, I do think that for the EAS, the question of privileges and immunities is the most important one. I do not believe that they care that much about protocol or having formal written black and white somewhere that they are treated exactly the same as any national embassy. I think the fact that if privileges and immunities are granted, I think that that would be enough of evidence that the UK is taking the EU seriously and that they treat them as an actor that has a place in its internal relations. I think that's the more important part of the discussion.
Sandra, I don't want to, let's say, prolong the discussion on customary law too long, but what would you say if somebody asked you the question, can the UK be seen as a persistent objector?
It could, but then we have to establish the rule on customary international law first, and then there can be persistent objectors, of course. Perhaps the question is whether the UK wants to be wants to be known as a persistent objector in this discussion, whether they have anything to gain in it. But then again, then you're making the thing a bigger thing than it should be.
Yeah, let's turn to Mauro. And Mauro, in fact, I have a third question that was specifically provoked by your statement that the EU should indeed, through Belgium, let's say, adopt a decision imposing Belgium to basically, let's say, deny certain diplomatic privileges and immunities to the UK ambassador or mission to the EU. The question was, can the EU really adopt such a decision? To what extent can it do that? And is Belgium then obliged to more or less implement that type of decision? So that's the third question, apart from the two other questions which were addressed both to Sandra and you. Please, Mauro.
Okay, let's start with this question first. I don't know whether there is any precedent in this respect, to be honest. I'm not sure whether Sandra knows something more than me. There is there? Pop in. That's probably easier, I guess.
Well, if I just may jump in, yeah, there has been a bit of precedent with NATO when there was a decision to scale down the Russian mission to NATO, and then I believe it was the Secretary General of NATO that formally asked the Belgian protocol services at the Ministry of Foreign Affairs to execute that decision, and the Belgian Protocol Office followed suit. I don't think there's any, I'm speaking in a very personal capacity here, but I don't think there is any reason why the Belgian Ministry of Foreign Affairs would not execute such a decision by one of the major international organizations that have a diplomatic practice.
Voila, okay. And then, yep, sorry. Then the problem is, of course, EU law as such. Under Protocol 7 to EU Treaties, Article 16, the host state, meaning Belgium, shall accord customary diplomatic immunities and privileges to missions of third countries accredited to the Union. Now, the literal interpretation of this provision would suggest that the missions of third countries must be granted diplomatic privileges and immunities. However, I think that a teleological interpretation of this provision should be preferred. The rationale for this provision is not to grant rights to third states. The rationale for this provision is to protect the European Union, its diplomatic relations, from Belgium, in the sense that the rationale for this provision is that is allowing the European Union to receive diplomatic missions without interference from local authorities, meaning Belgium. So in a way, if the European Union can ask Belgium to give the UK mission diplomatic privileges and immunities, so the full diplomatic privileges and immunities, I think that the European Union also has the right to ask something less, so functional diplomatic privileges and immunities. When I wonder whether there is any specific precedent regarding the application of Article 16 of Protocol 7. I don't think there is, but I might be wrong. Anyway, I think this might be feasible, and I don't really see any reason why this could not be done. And I seriously doubt whether the UK would take the issue to the Court of Justice. It could, theoretically, but I don't think it would. So technically, I think that this might be a way to go, and if when the push comes to shove, it should be the way to go, in my understanding. And having said that, coming to Ramses Vessel's question, which is really nice, I think that one of the main reasons why we should talk about the functional immunity, the functional analogy between EU delegations and states, is that well, this is, I think, a supporting argument that you can use pro or contra the argument regarding the customary nature of EU delegations' privileges and immunities, in the sense that it would obviously not be sufficient to establish this functional analogy to argue that EU delegations should receive privileges and immunities, diplomatic privileges and immunities. So it is not a sufficient argument per se. However, I think that it might serve the purpose of reinforcing one argument or the other. And that is, Professor Denza will correct me if I'm wrong, that is probably also the reason why Professor Denza specifically, but also the British government made a claim that EU delegations actually are missions of international organizations, like the missions of other international organizations. It is a rhetorical argument, it is a motivation, it is a political statement, which I think might have borderline legal consequences, in a sense that it legitimizes a certain reading of customary law or their absence thereof. So in this sense, I think that this is an important argument to make or to disprove. And I think that that's it as far as I'm concerned. The argument regarding the persistent objector, I think that Sandrine has answered it eloquently, and I don't really have anything to add in this respect. Thank you.
Thank you very much, Mauro. We are not far away from the end of this panel, but I still had a question for Ambassador O'Sullivan and also for Professor Denza. We got, well, I in a way already produced or mentioned that question, but let me phrase it specifically to Ambassador O'Sullivan. Would you be inclined to think that the UK stance follows indeed a similar attitude or strategy as the Trump administration, and added as the Kremlin, namely to downgrade the EU under the motto divide and rule, divide et impera? Ambassador O'Sullivan?
Well, I think I've already said that I really don't think there's any comparison between the incident that I experienced with the Trump administration and what we're talking about here. This was, you know, the only issue in play was that the position of the EU ambassador in the sort of protocol list of precedents, and whether you moved up or down the list in function of seniority. There was never any question about the diplomatic status or indeed the application of the full range of immunities. I also don't think, but that's, you know, for my memoirs, I don't think this was actually a decision taken at a high level in the White House. I think it was taken at a much lower level. I think in this case, we're dealing with something quite different. We're dealing with a very conscious decision of the UK government to make an issue. I fully respect what Professor Denza has said, that there are real issues there for the UK, but they have chosen to make this an issue. I would just like to mention two things, if I may. One is on the issue of reciprocity, which we've just been talking about. My understanding, and I'm speaking here in a purely personal capacity, but my understanding is that the EU institutions have actually asked that the accreditation of the new British UK ambassador be put on hold pending a resolution of this issue. So I think there is already an element of poisoning of the sort of, you know, spillover effect of this here in Brussels. The other point I just wanted to make, and I mean it's not a legal point, but I think it is an important point. Under the Lisbon Treaty, the EU ambassador is the primus inter pares of the member states for European Union issues, not for their bilateral issues. So it is he or she who chairs the meetings of the ambassadors. It is he or she who kind of speaks on behalf of the 27. It would be very strange if somehow the status of that person or their mission was less than that of the people, you know, the other member states. I think this is, it's not a major point, but I think it's another element in the file which pleads for absolute equality of treatment across the full range of the diplomatic practice for the EU delegation. And so I think, as I've always been inclined to take the view that, these protocol issues should not keep us too much awake at night. Professor Denza, right, and she's devoted a considerable career to this, and rightly says that these are actually very important issues, and our younger academics are going to have, I wish them as successful a career as Professor Denza has clearly had, and the same level of expertise. But these are important issues. And as I say, my one regret is that this has now entered the public domain in the way that it has, which makes it even more difficult to resolve. My experience of diplomatic matters is the more you can deal with issues before they become public, the easier it is. Once it goes public, then positions are taken from which it is difficult to walk back. I'm certain that both sides will try to find an elegant way out of this. I hope that is possible. But I do think for the European Union, this is not a trivial issue at all, and one which will be taken very seriously, not only by the institutions, but by our member states. And I can, final comment, when I had my little incident, what shocked me or surprised me very pleasantly was the degree of support I got from the member states. They were almost more offended for me than I was for myself. And I found that a demonstration of the enormous loyalty that member states show to the EU delegation. And I think this will also be seen in this instance.
Ambassador, in fact, while you were speaking, we had two other questions popping up, and I don't want to needlessly stretch our panel for too long, but I found them relevant, especially because one of those questions comes from a former EU ambassador. And so the question there is basically, as the issue appears to be a political one, what political arguments would you think that the government of the UK would be ready to consider in order to maintain the fully fledged diplomatic status of the EU delegation? And the other comment is actually, it's a bit also in the political line of thinking. Is it possibly so that the UK, in doing this, in having this diplomatic spat, would actually like to be this spat exactly in the public space and in the public debate in order to expose the EU, and then maybe at a later stage further politicize the issue? So, I mean, just very briefly, your reaction to those 2 points?
Well, look, is this being instrumentalized? I would sincerely hope not. I take very seriously what Professor Denza has said, and not only her academic experience, but her experience as a practitioner, that there are real issues in the mind of the UK which need to be resolved. And I take that at face value, that they have concerns, they have a certain interpretation of these matters going back many years. So I take it at face value. The risk that it gets instrumentalized is clearly huge, and the more it goes into the public domain, the greater that risk. What political argument? I mean, look, the argument I would use is, when you look across the board, there is a practice there which is pretty much universal across all member states, across all third countries. The UK has an interest in that the EU delegations, particularly in difficult and delicate contexts, of which there are many, is able to function fully with the full range of immunities, enabling them to deal with corruption, with human rights, enabling them not to fear for the welfare either of the diplomats or of their families, because as Professor Denza said, this can be a point of leverage in certain regimes. The UK has an interest in that, and therefore, and more importantly, the UK has an interest that the EU delegation in London is able to facilitate the flow of information and understanding on such a range of issues that we're going to have to deal with post-Brexit. I mean, the withdrawal agreement and the TCA have only scratched the surface, and we're seeing it every day. And really, is this the time to then have an argument about, the precise conditions of setting this up and how it's going to function, when in fact what we need to do is deal with the substantive issues, and we need a functioning diplomatic dialogue, both the UK here in Brussels and the EU in London, in order to grease the wheels of that machinery, which are going to be frequently very stiff and rusty without very great diplomatic tact.
Thank you very much. Professor Densa, if I quickly may, there was still a question specifically to you, and it comes from another partner in the EU Diplo project, and that is Professor Sara Poli, Professor of EU Law at the University of Pisa. And she asks the following question to you. Don't you think that the denial of full diplomatic immunity will deeply affect the close cooperation that the UK and the EU want to have in the field of CFSP, in the field of common foreign and security policy? Could that cooperation really work if the UK denies full immunity to the EU? Please.
Well, I would think in that context, the important issue is it comes back to functional immunity, and there a few times the discussion seems to have gone into areas as if suggesting that the UK is denying official act immunity, which is absolutely not the case. The issue is purely on the full range of personal Vienna Convention level immunity for conduct which has nothing to do with official acts. As to its coming up late, I think there is a doctrine among British diplomats which is known as the permanent unripeness of time. I think that even in the context of the later stages of negotiating the agreement for future relations, there were indeed more urgent topics, and the question of status could not really definitively be argued until that was resolved. A number of, just one concluding thing I would say about it being somehow necessary for the EU staff and their members of the family to have immunity for acts which are nothing to do with official capacity. I was taken back to when we were negotiating this Strasbourg guidance within the context of all members of the Council of Europe, and I did this with Sir Vincent Evans, who went on to become a judge of the European Court of Human Rights, and we would conclude after discussion that such an organization could not have personal immunities, and it would always end up with, for instance, saying, right, they'll just have to behave themselves. So I rather felt that once or twice. It's not the issue has got to be legally pointed out, and the UK did have a discretion to give treatment full immunities up till 1964, and we used it for the Baltic states. They were given immunity by courtesy, and the 1964 Diplomatic Privileges Act, by which the UK gave domestic effect, the Vienna Convention, took that away, and the poor old little delegations of the Estonia, Latvia, and Lithuania lost their inviolability. We don't have this, so the UK can't be just clever. It's not a question of how clever Boris Johnson or anyone else in the government is. It is a question of what the legal constraints are, and they are real. Just one final thing, and again, it comes back to what's emerged a number of times. What I'm saying about the legal constraints on full immunity don't apply to the questions of protocol and precedence. They are within what we call the royal prerogative, or the prerogative, and it might be possible for a solution that would be helpful to the European Union politically to deal with without legislation. This is, however, not at present, as I see it, the case for full immunity for all members of staff, right down to the doorkeeper and the doorkeeper's 17-year-old drug-taking son, let's put it crudely. Thanks.
Thank you very much, my dear colleagues. This has been really a very stimulating and fascinating panel discussion, but we are reaching the end, and we are already a bit in overtime. So I would first of all like to really thank very warmly our distinguished panelists, Ambassador O'Sullivan, Professor Denza, Drs. Duquet and Maury, for sharing their expertise and experience. It's, I think, been a wonderful combination of practice and academic expertise. I hope you all enjoyed that, and I'm grateful for the many questions we got from our audience. I would also like to say, well, we didn't maybe provide you with an operational general conclusion of this debate, but if you have listened carefully, I think there are quite a number of ideas that, if pursued wisely, could lead us to a kind of an end of the stalemate. So I think the careful listener may have detected some good advice to help solve this particular issue. I would say at the end of this debate, please stay tuned to the EU Diplo Jean Monnet network, because we may indeed organize similar informal events in the near future. And in fact, we are open for your suggestions. I've noticed that there are many people participating here, including distinguished former EU ambassadors. I'm pretty sure that many of you have lots of experience and lots of things to tell and to share. And even if it is about what I would call more bread and butter diplomatic law questions, I think we would be very grateful if you could share them with us, because indeed it's very often those bread and butter questions that may have much deeper underlying issues. And that's exactly what the EU Diplo network is all about. So again, great gratitude to our panelists, to all of our audience for their interest, and we hope to see you again very soon. And now let me just wish you a great day, and see you next time. Thank you very much. All the best.
Thank you very much. Bye.
Bye.
Goodbye.